All right, let's get started. We have a great panel to kick this day off. It's on SEC practice, and we have a really terrific panel. So let me start off by introducing John Berry. John is a partner at Munger in Los Angeles, and he was previously an associate regional director and regional trial counsel in the SEC's Los Angeles office. Welcome, John.
Thanks.
Jason Lee is here from the SEC. He's Associate Regional Director in the San Francisco Regional Office, and he joined the SEC in 2013 and was a member of the Enforcement Division's Public Finance Abuse Unit from 2015 until 2022. Welcome, Jason.
Thanks, happy to be here.
Also very pleased to welcome Sarah Mallett, a partner at Kirkland and Ellis in Dallas as of last month, who was previously Assistant Director in the SEC's Division of Enforcement, where she served for 7 years. Sarah, welcome, and welcome to Private Practice.
Thank you. Good morning.
Very pleased to welcome Andrew Michaelson. He's a partner at King & Spalding in New York, and he previously served in government as senior counsel in the Division of Enforcement at the SEC, and also as a special assistant U.S. attorney with the Southern District of New York. Welcome, Andrew.
Thank you.
Finally, very pleased to welcome back Susan Resley, our moderator. She's a partner at Morgan Lewis and leader of its San Francisco litigation practice. And Susan herself previously served in SEC's Enforcement Division, which she joined right out of law school, I think.
Yeah. When they used to let us do that.
Well, Susan, thank you, and take it away.
Great. Thank you, everyone. We're going to kick it off just by focusing on the fact that this has really been a banner year involving the Division of Enforcement. We've seen significant trials, and there have been a number of court orders which have, really had an impact on statutory and rulemaking interpretation. And of course, the future of APs remains in limbo right now. Our panel is going to provide insight today on these issues, as well as their valuable views and expertise involving negotiating settlements, as well as navigating the Wells process and dealing with testimony in this hybrid environment. So we have a lot to cover today. Jason and Sarah, why don't you kick us off with just the state of play within the Division of Enforcement, given that Jason, you're still there, and Sarah, you still have very fresh insight.
Sure. Good morning, everyone. So I'll kick it off. State of play at the division right now. It's busy, and I expect it'll get busier. July 1st marks the beginning of the last quarter for the division's fiscal year. And we've had 2 fiscal years already in the books under the current division leadership that have kind of set the trend of what I think we are continuing to see and can continue to expect to see, which is that this commission has proved to be pro-enforcement and will approve cases that are somewhat novel, that have relatively high penalties, that continue to focus on gatekeeper liability and individual liability. So the announcements have been coming in, and I think we'll continue at a faster clip as we get closer and closer to September 30. Perhaps something that has changed more dramatically in the past few years, and Susan touched on it, is the effect of the hybrid environment on the entire world, but also on the division. I think it's manifested itself in 2 ways primarily. One is that there's an increased cross-staffing throughout the division. The specialty units have been doing cross-staffing for years, but I think you're going to see it and have seen it move into more prominence throughout the division. So it would not be uncommon to see staff from different offices on an investigation, perhaps supervised by a supervisor even from another office. I think it's a good way for the division to leverage the talents and experiences of the staff without being beholden to a specific geographic location. You mentioned testimony. That's changed a lot. The division was doing largely virtual testimony for a long time, and now it has trended back in some ways towards in-person testimony. I don't think that virtual testimony is going away. I think it's an important part of the division's toolkit. for me, when I was at the staff, there were kind of three primary factors that drove the decision-making process on virtual versus in person. The most important factor was just the type of witness. So if there's a lower level employee, a cooperating witness, an investor victim, I think you're going to see a trend towards virtual testimony. Someone who may be an important witness at trial or potential defendant or respondent, you're going to see a trend towards in-person testimony. I think the second factor is, quite frankly, just the preference of the staff and his or her supervisor. And then the third factor would be the pace of the investigation. So if it would take 3 or 4 months to schedule an in-person testimony versus 2 or 3 weeks to schedule virtual, then you may see more virtual testimony in any of your investigations. There are 2 trends that I would expect that you will see even for in-person testimony. And that's that even if the core participants are in person, I would expect a hybrid appearance or a virtual appearance from other members of the staff, paralegals, accountants, economists, trial attorneys. Also, many offices are moving towards electronic exhibits. So even if the testimony is in person, the exhibits will be shown electronically in the room. So these are just questions to dialogue with the staff about early and often, what the logistics will be. If you have a strong preference for a forum of in-person versus virtual, make that known. It might be a factor that the staff takes under consideration.
Great. Thanks, Sarah. Jason, one of the trends that we've seen quite a bit have been sweeps. I think there's not a week that goes by that we don't hear, even internally within the office, of, have you heard of this sweep? Have you heard of that sweep? Tell us a little bit about that and how that's become a significant part of the enforcement program.
Yeah, so definitely a lot of sweeps, initiatives. And the reason I think that's the case is because there's a lot of benefits to it. I think, in particular, the enforcement program thinks there's a lot of useful applications of it, right? In conjunction as one tool as part of our overall enforcement program. They can be an efficient way of addressing recurring or widespread violations in the securities industry. They can help send important messages to participants in the industry. Relatedly, there can be a more pronounced deterrent effect if there's a group of folks being brought into a particular sweep. I think that it can also empower compliance folks, maybe even empower folks here working with clients in terms of flagging the particular significance of certain types of regulations and to be in compliance. I would say that you tend to see, but some of the sweeps are part of or emanating from particular units of the SEC. But that's not always the case. It's not always going to be a unit specific. If you see a sweep, it won't be just because it's part of a unit. There are plenty of sweeps that are being run out of the core of the enforcement program as well. And I guess real quickly, I'm not going to go into the details of particular sweeps, and some of these I'm sure you all are already familiar with, but one of which is the off-channel communications matter. When I came in fact, at 7:20 when I arrived bright and early today, there was a mention of off-channel communications and a little sidebar that I was a part of. I'll just say that since December 2021, when that initiative was first public, the first set of actions were brought out, the sweep has included broker-dealers, investment advisors, credit rating agencies to try to encourage compliance with record-keeping requirements, and has resulted in charges against nearly 60 firms with over $1.7 billion of penalties. And then just 2 other quick examples. There was a marketing rule sweep that was resulted in some cases in September of last year, where the commission brought charges against 9 registered investment advisors for advertising hypothetical performance to the general public on their websites without adopting or implementing policies and procedures as required by the rule. And there are more, but the last one I'll just flag now is there's a Form 4 and Schedules 13D and 13G initiative. Again, September of last year, that's when the wave of cases were brought. There were 11 filed actions as part of that initiative, focused on ownership reports that company insiders are required to file regarding their holdings of company stock. And you can read about this. I mean, you already might know about these initiatives and sweeps. They're certainly available on the SEC's website, and there are more. But it's an important tool.
Yeah, your data analytics people have been very busy. John, were you about to say something?
Yeah, what I think is interesting about the sweeps, because we've definitely seen it, the SEC has been much more aggressive, as Jason pointed out, doing these sweeps. I always feel at some point, some company is going to say, wait a minute, the SEC has no inkling or suspicion that our company has done anything wrong. We're getting swept up among like 300 others and being asked to provide information and documents, and the SEC saying, if you do this, we might go light on you, but if you don't, there's going to be some draconian penalty if you don't cooperate. And at some point, I feel like someone's going to say, wait a minute, you've got to have more than just, hey, we want to investigate you. You've got to have, everybody knows that they don't require probable cause at the SEC, but you've got to have something more to be able to sweep up 300 entities without any belief that every entity there did something wrong. And so it to me, and maybe I've made the full transition from SEC to defense lawyer now, but to me, that could end up being a problem at some point, because you can't just investigate somebody without at least some suspicion that the entity's done something wrong.
Hey, so I forgot to do one very important thing.
Jason's not even responding to that.
Well, I can respond to that, but as is customary, I want to quickly note that the views I express today are made in my capacity as an Associate Director of Enforcement at the SEC, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the SEC staff. Thank you for reminding me, Sarah. And that applies to my prior statements, too. The only thing I'd say, John, I hear your point, but and Sue alluded to this too. There's data analytics. There is a system the SEC staff tries to employ to be reasonable in terms of identifying firms or registrants that could be at higher risk for a particular issue, whether it's a marketing rule violation or a books and records issue, before reaching out and requesting the records. So I hear your point, but there is an effort to try to be reasonable there.
Yeah, and because I realize they have that, and I think that's important. The sweep I think of when I sort of paused and saw how it played out was the SolarWinds sweep. If people aren't familiar with that, that was companies who had been victims to the cyber attack, and the SEC, I think it's hundreds of companies were subject to that sweep. And a lot of these companies, the SEC had no idea, didn't even think they might have done something wrong. They just wanted to find out what they did internally.
They were
in
the
response
victims.
to it. Yeah. So that one was an example that made me pause and think, these sweeps are getting fairly aggressive.
Yeah. So turning to trials next, and this was a very busy year. It's very clear that the SEC is not afraid to try cases. You almost feel like when you're negotiating with the staff, it's like Clint Eastwood, make my day. So why don't you tell us, there were obviously two significant trials, Terraform and Panawatt, and we know the insider trading panel will probably cover Panawatt quite a bit. But Jason and Sarah, why don't you just briefly describe Terraform and Panawatt?
Sounds good. And this is the benefit of going at 8:10 a.m. The last panel I was on, I was at the end, and everything I want to talk about was already covered. But I'll try not to steal the win from other folks because I know there is an insider trading panel. So, general theme, I think, is that the SEC is, willing to take cases, to litigate cases. So first of all, going from investigation to litigation. It doesn't mean we're going to just litigate willy-nilly. Obviously, it has to be something we believe in. We have to feel like there's an enforcement violation. But there is a willingness to litigate if necessary, a willingness to take cases all the way to trial if a satisfactory resolution for all parties involved can't be reached prior to that, and a willingness to litigate and go to trial for what I'll call like hotly contested or high-profile issues. And these include issues that some folks might consider more cutting edge, right? I mean, I think it depends on what your perspective is in terms of whether you would say the SEC is pushing the envelope, or from our perspective, we're just applying the securities laws, right? But it's an issue that I can acknowledge is hotly contested and in people's minds. So two examples were the insider trading case against Matthew Panawatt, SEC versus Panawatt, and also the Terraform and Do Kwon case in the Southern District of New York. So I'll try to keep it relatively brief. I just want to give you a little bit of background, though, and give you a sense of why there are noteworthy matters, and I think maybe emblematic or representative of the commission willing to go to trial to bring these cases in areas where the law might not be as clear or as established or where it's hotly contested. So for the Ponowat matter, this was tried at the end of March into April. The final day was April 5th when we had closings. And this was an insider trading case against the defendant Matthew Ponowat, Northern District, California in San Francisco. It was a 8-day trial, and on April 5th, after deliberating for a little over 2 hours, the jury came back in favor of the SEC and found the defendant liable for insider trading. So this is what people in the industry have called shadow trading, substitute security trading. I'll get to that in a second. I think Gurbir Graywal, our Director of Enforcement, and staff at the SEC have been clear that from our perspective, while the facts might have been somewhat unique in the circumstances here, the theory of liability itself, based on misappropriation, wasn't, right? And people can disagree with that, but in our minds, and I think in Judge Orrick's minds, in his motion to dismiss and summary judgment opinions, was pretty clear that the theory falls in line with traditional insider trading theories. But just quick highlight, I proven at trial, Ponowat, the defendant, who was the then head of business development at Medivation, which is was a biopharmaceutical company, purchased options in a peer biopharmaceutical company called Insight, just days before an announcement that Pfizer would acquire Medivation at a significant premium. So the issue here, right, was that the defendant had purchased options, call options, in the securities of a company that wasn't his company, right, based on MNPI, material non-public information, related to an acquisition of his company that he believed would have an impact on other securities prices, including Insight. So the securities were purchased minutes after he got an email from the CEO of the company indicating that the deal was very likely to be closed over the weekend. This was on Friday, and bought out of the money call options with short expiration dates. So telltale signs classically of potentially insider trading. So like I said, the case has been widely viewed as or characterized as shadow insider trading, as something suggesting that it's different than quote unquote like typical insider trading case. But again, I submit that while the facts might have been somewhat unique here, the theory wasn't. And at the end of the day, the elements were the same as in all misappropriation cases. Defendant owed a duty of trust, confidence, or confidentiality to his employer. As a result of his relationship and role at the company, his employer, he had access to confidential information. The information was material to Securities, that he traded on it. There are more elements, but I'm just trying not to go through all of it. So that's one example, right? I just bring that up because it was in the press a lot and something a lot of folks talked about. And at the end of the day, we couldn't without being able to reach a resolution, we went all the way to trial. The other is the Terraform and Do Kwon case, which was in the Southern District of New York. On the exact same day, April 5th, the jury came back after 9 days of trial and found Terraform and Kwon liable for fraud in connection with various crypto asset securities. The case involved various crypto asset securities, including Terraform's Luna token and also what they purported to be an algorithmic stablecoin, UST, or I guess it was called Terra USD, but it's generally referred to as UST. And in February 2023 was when the case was first brought by the SEC, and it charged Terraform and Kwon with defrauding investors, raising billions of dollars through their offer and sale of those crypto asset securities. And when the fraud fell apart, it resulted in a $40 billion loss of the market value. So very significant, as most of you probably are already aware. Just kind of wrapping up here, the main points I want to make are that the defendants misled investors about the stability of the so-called stablecoin, which is supposed to be pegged to the US dollar and use code to keep that peg. As it turns out, that wasn't the case. And similarly, the commission proved at trial that Terraform and Kwon deceived investors about Terra blockchain's ability to settle the transactions of a popular Korean mobile payment application, which was claimed that capability and deal was supposedly going to raise the value of Luna. So that's just a little bit of background on the case. You can read about it online at the SEC website or in the news. But I bring that up really because it involved crypto asset securities. It involved a purported algorithmic stablecoin. So however you want to characterize it, cutting edge issues. And just an example again of the commission's willingness to go to trial if necessary to litigate.
Can I make one follow-up point on that, Susan? So I agree with Jason. The division is willing to go to trial, and the SEC's win record in district court is still very, very high. It's like in the low 90s. But that tends to vary across circuits. And so while arguments of litigation risk may not be as persuasive in a settlement context as they once were, it may have an outsized influence depending on what district court or potential circuit you're in. So being from the Fort Worth Regional Office, filing within the courts of the Fifth Circuit, I think there's still some strong arguments to make about litigation risk to the SEC.
Great, that's terrific insight from both. John, tell us about some significant cases that have not gone to trial, but there have been some interesting rulings even at the motion stage.
Yeah, and I'll try to keep this short since we're getting already with just 25 minutes left. But I think there are three cases that I think were sort of things that are worth following for the defense bar. One is the SEC v. Prakash case. Mr. Prakash was the CFO of View Inc. And what's interesting about that case is the SEC brought a only negligence-based case against the CFO as an accounting violation, but still sought a D&O bar in the litigation. And under the Exchange Act, the statutory basis for a D&O bar, you need to bring an intentional fraud claim, like a 10B claim. So this was highly unusual, and to seek a D&O bar solely through the equitable powers of the court rather than through the statutory framework. And that actually got litigated to motion to dismiss, and the judge said, well, there are cases, they're not many, but there are cases that say that the courts have the equitable power to impose a director and officer bar. The court, Judge Freeman did say, the fact that it doesn't happen this much, and I think there's only one example the two sides could come up with, she said that sort of underscores the severity of the remedy, which I think it's going to be interesting to watch this play out in this case as it's litigated. Is a court going to impose a D&O bar on a negligence-based case? Now, I've heard rumblings that the SEC is going to start doing this more often. I mean, often you would think, 5 years ago, you think, well, if I can just get to a negligence-based a negligence-based settlement, the SEC is not going to impose a D&O bar. But I don't think that's the world we live in anymore. So I think it's one important case to follow. Another case line of cases have to do with disgorgement. It's funny, for a long time, disgorgement was this sleepy little remedy nobody even cared about. And now it's been going up to the Supreme Court repeatedly. You had co-cash on the statute of limitations. You had the SEC v. Liu case. That was actually a case that I litigated. It was an offering fraud. Standard practice in the SEC to go get disgorgement and get the full amount of the offering proceeds. And the Supreme Court said, no, you can't do that. Case to watch in this area is the SEC v. Govil case, Govil, which is the Second Circuit case. And the Second Circuit said, based on Liu, said, to get disgorgement, the SEC needs to prove investor harm and send it back. And I think that's probably going to work itself out in that case. That was also an offering fraud case. It's just the district judge, Judge Etkin, didn't have evidence of investor harm. But with that decision, you're going to start wondering, well, how does that work for an insider trading case or an FCPA case or all these crypto cases where it's just a Section 5 failure to register case? Those are all cases where the SEC traditionally has gotten disgorgement. But if you follow what the Second Circuit is saying, the SEC has to prove investor harm. Proving investor harm in an insider trading case, proving investor harm in a bribery FCPA case, or proving investor harm in a failure to register case could be very difficult. So that could scale back the disgorgement remedy for the SEC. What's telling is, right after that decision came out, the SEC reported to the district judge, hey, we're thinking about going to the Supreme Court for this. They did not, because they have another case going to the Supreme Court called SEC v. Ahmed. And that is actually looking at whether or not, after the Supreme Court came out with the Liu case and scaled back and limited the equitable remedy, Congress enacted the National Defense Authorization Act and put in codified the disgorgement remedy for the first time. It's now part of the statute. And in the Fifth Circuit, we just talked about the Fifth Circuit said, now they've codified it. All those limitations the Supreme Court spelled out in lieu, those are for the equitable disgorgement remedy. The statutory remedy doesn't have those limitations. That's what the Fifth Circuit said. Second Circuit came out the other way and said, no, this new codified disgorgement remedy that's in the statute, it still has the same limits as lieu. So you've got a circuit split, and I think that's going to be important to see how that plays out. The last one I would point out is the Lorenzo scheme liability, and just to touch on that quickly, that has always been, I think, an issue, right? Janus scaled back what the SEC can do. They've said you now have to prove that the defendant was an actual maker of a statement in order to be liable. Before that, all sorts of people were being pushed to the limits for liability in terms of misstatements cases. And then the question was, the SEC was dealing with a lot of people who didn't make the statement, but they really wanted to go after them, and that happened in the Lorenzo case. I know we're all familiar with it. That was some guy who sent an email out that he knew was false, but he didn't draft it. His boss did. And so the Supreme Court said, well, that counts. That's dissemination. That's scheme-like. And so now the whole question is, so what counts as scheme? Can you have a misstatement-only case, but make it a scheme case so you don't have to deal with the Janus problem? And now we're seeing a little bit of a circuit split here. The Second Circuit has said in Rio Tinto, you've got to have something extra. It can't just be a misstatement case. You've got to have something scheme-like extra for the SEC to bring that kind of case. The Ninth Circuit hasn't quite touched on it, but they've suggested it in a private litigation against Google, the Alphabet litigation. There's a footnote that sort of says, hey, it looks like Lorenzo abrogated our prior decision, WPP Luxembourg decision, that sort of said these things are siloed. And so the Ninth Circuit has suggested maybe they think that you don't need anything extra. So I think that's going to come up to the Supreme Court at some point, about whether or not you really do need something extra. And I think where that matters is for those representing companies, you've got people who sign the SEC filings. They're going to be makers under Janus. But what about the people below that who are providing input, who are providing significant input? Janus would say they're not enough. Can they get hooked with scheme liability? It's unclear right now, and I think the Supreme Court's going to have to figure that out.
No, that's really, really interesting just to see the development. Mm-hmm. Speaking of development, Andrew, tell us about what is going to happen with the future of APs, just given Jarchese and how the SEC is handling AP matters.
Well, if you're asking me to predict how the Supreme Court is going to come out in Jarchese, that'll be hard, but I can shed some light on what we think is going to happen based on the Supreme Court argument and what to be looking out for. I would say, and this may be a heretical view among the defense bar, but I welcome the SEC's efforts to bring litigated cases in federal court, to put their proof to trial, to put their proof to the judges and to the juries, because I think it makes ultimately the SEC enforcement staff smarter about how they investigate cases, how they think about evidence, how they bring charging decisions. You have to be put to your proof to really to learn that. So I welcome the litigation efforts of the SEC, and you don't get the same learning in an administrative proceeding because there's no jury, which was a significant issue to the Supreme Court. Administrative proceedings, you may not have been paying attention to them recently because the SEC has been using them sparingly since the Fifth Circuit's decision in Jarchese 2 years ago. You'll still see them in settled cases, follow-on cases, occasionally where there is a remedy or a cause of action that can't be brought in federal court, like a 102E case. But we haven't seen them much, but that's going to change once there's clarity from the Supreme Court on the use of administrative proceedings. When the Fifth Circuit ruled in Jarchese, they struck down the use of administrative proceedings in a fraud case on 3 separate constitutional grounds. They said it violates the Seventh Amendment right to a jury trial. This is the Fifth Circuit decision. violates the Seventh Amendment right to a jury trial, it violates the non-delegation doctrine, and it violates the take care clause. The Supreme Court heard argument on this several months ago and focused almost entirely on the first issue, the right to a jury trial. The other two issues, I think, are unlikely to dramatically shape the future of APs, and I'll just quickly say why. So the second issue is the violation of the non-delegation doctrine. This speaks to the principle that Congress can't delegate to the executive branch a legislative function. If it's lawmaking, Congress has to do that. They can't let the executive branch do that. And the Fifth Circuit ruled that this decision that SEC lawyers make all the time, should we proceed in an administrative proceeding or in federal court, that's a legislative function. That's what the Fifth Circuit ruled. The contrary argument is that's not really legislative in nature. That's prosecutorial discretion. People do that all the time in the executive branch. And the Supreme Court didn't really engage on that issue and is probably likely to reverse. The other issue that the Supreme Court didn't really address in the oral argument was the take care clause. This speaks to the principle of Congress can't impede the president's ability to administer the executive branch. It's up to the president to administer the executive branch, and Congress arguably did that here by writing into a statute that administrative law judges can only be removed for cause. There's a for-cause removal in the statute. The Supreme Court may well uphold this. They may say that the for-cause removal violates the take care clause, but there's an easy fix for that. They can just write that out of the statute. They can just strike out the for-cause removal provision, and then APs can proceed. It's just that ALJs would be more easily removed by the commissioner, potentially the president. So those two issues, I think, are unlikely to dramatically shape the future of APs. But the right to jury trial is what the Supreme Court really engaged on. This goes to the Seventh Amendment of the Constitution. If you haven't read it recently, it says that in suits at common law, where there's at least $20 at stake, the right to the jury trial shall not be, the right to jury trial should be preserved. And I checked, the $20 is actually in the Constitution. And it's not inflation adjusted. What several justices, Gorsuch, Thomas, Alito, they likened securities fraud claims to common law fraud claims and said essentially they're the same elements, it's the same kind of claim. The SEC, I gather, was seeking more than $20. I didn't check in that case. And so they said that their questioning implied that at least those three judges had a real problem with a Seventh Amendment violation. Three justices on the other side of the spectrum were on the other side of the spectrum. Their questioning suggested that the Seventh Amendment really only applies to common law claims. And as we all know, the securities fraud claims are not common law claims. They're claims created by statute, and those justices questioning suggested that their view was that Seventh Amendment wouldn't affect the SEC's ability to proceed in an administrative court. How they rule remains to be seen. We'll find out within the next, this term, so within the next month or so. But here's the upshot. Here's what to look out for when the ruling comes out. If there's no Seventh Amendment violation, no right to trial issue here, then I think we can see the SEC return to bringing fraud claims and all kinds of claims in administrative law proceedings. If there is a right to a jury trial issue, if there is a Seventh Amendment violation, I think three things may happen. One is we may see administrative proceedings used only for more technical violations, like books and records. We might see some interesting litigation about variants of fraud claims that don't have a common law corollary. This speaks to some of the scheme liability questions that are percolating in the courts. There might be some fraud cases that don't have a common law corollary. We might see litigation over that. And the third, which Jason, maybe you can address in your personal capacity is whether the SEC, we could all push for this, whether the SEC might cap disgorgement and a penalty at $19.99 and then use administrative proceedings wherever they want.
No, that's great. And in the interest of time, what I'd like to turn to next is really those events leading up to litigation, APs and the like. And that's really this time of year, which is what we often call the Wells season. And what I thought we could cover, and John and Andrew, why don't you kick it off? And then it'll be great to hear Jason and Sarah's perspective. When do you counsel your clients as to, do you do a Wells submission? Don't you? Do you do a white paper? How does this play in with settlement? So we're going to just weave everything all together. So I'll kick it off to John and Andrew at the outset.
I'll go first. So I think a lot of us know this, but I think in terms of what do you do a Wells submission and whether or not you want to go in that Wells process, obviously as a public company, that can be a big thing, right? You get a Wells notice, then you're starting to think about what disclosure obligations you have. So I think it's the public company thought process is different than for individuals, for example. You're going to want to think, maybe can we avoid this? Can we do white papers? Can we talk to the staff? We've been cooperating. Let's avoid the whole Wells notice and try to resolve it then. But other than that dynamic, I think Wells submissions are very, very important. And from my perspective, for what it's worth, I think, the audience for me when I do a Wells submission isn't the commissioners, and it's not really the staff investigating it. They largely think this is a case, and usually their immediate supervisor thinks it's the case. The target audience are the associates, the head of that office, the trial counsel, the regional trial counsel, who haven't been in the weeds of the case, but now have to make a decision with the investigative team whether or not to bring the charges or not. And so I think it can be hugely important. I actually think even more important than the Wells submission is the meeting you have with the staff, the in-person meeting where you go through your arguments, because you can do things you don't necessarily want to do in a Wells submission, because I always think Wells submissions, don't forget, they're admissible in court. I did a pretty big insider trading case where we admitted when I was at the SEC, when we admitted the Wells submission into court as evidence. So there's things you don't want to say in writing, but in that meeting, you can acknowledge things and be upfront with the staff, which I think the staff obviously appreciate a more upfront conversation. So I think Wells submissions are critical.
I think the best Wells submission is the one that you don't have to make, because it doesn't get to that stage. Once you're at that stage, I think you've really got to think hard, especially with this commission, about whether minds are made up, what minds can you affect and change, and how, or might this Wells submission be used against you in trial. So I think it's very context specific. To relay one quick story, a recent story, I got a call from the staff saying, this is not a Wells call, but next week we're going to Wells your client, and they laid out the charges, and your Wells submission is going to be 2 weeks later, and there will not be any extension. And they had not taken my client's testimony yet. That sort of came out of the blue. It was the most Wells call, non-Wells call I've ever had, and to the point of whether that's very context specific. This was in the crypto space. And where I think the commission's views on the core issues are well known, and so you have to think, okay, what is a Wells commission going to accomplish in that context?
So what is your perspective, Jason and Sarah, on the utility of a Wells submission or a white paper?
I think that there's a high utility for a white paper or Wells submission. I think John was spot on in that your audience should be the associate, the division directors, trial counsel, certainly. And I think it's no secret that there's less and less likelihood of getting a Wells meeting with the division leadership, with the directors. But I think I would jump at an opportunity to have a Wells meeting with regional trial counsel and the associate. I think I agree with John that there's a lot that can be said in the room that would be persuasive to those decision makers. And I think in my experience, it would be a mistake to think that no one cares about a Wells submission or a white paper, that indeed those conversations are happening frequently and often as an action gets closer and closer to commission consideration, and may adjust charges or penalty ranges, may have a fresh perspective on litigation risk. So I think they're an effective tool.
So just briefly, I think Wells submissions are important. I think at the end of the day, we want to get the decision right. And part of that dialogue and part of that process is the Wells process. And again, I agree with John, it's not just the written submission, it's the conversation that happens in the context of the Wells submission. I will say, and this is just my 2 cents, and there's different reasons why you might take a different approach. I think for an effective Wells submission and then discussion, it's really important to maintain your credibility and really focus on the core issues, not be over the top. I know that there's a strategic decision that has to be made about whether making concessions or not, but obviously conceding or at least not pushing points where the evidence would indicate it's not a good point to push helps the credibility and helps focus the issues, right? Like, is there an actual cause of action or set of causes of action that can be eliminated? Is there a particular type of remedy that maybe doesn't seem to be fit properly based on the conversation, rather than just kind of throwing everything on the wall, right? And the best analogy I can think of is, you think about probably not all of your briefs in litigation, right? But you think about some briefs that are submitted, right? It's like everything thrown against the wall, very aggressive positions, over the top language. And you can imagine that that's not going to necessarily help efficiently focus issues, right? So that's the main thing I'll throw out. And then just to piggyback real fast, I know we're short on time, equitable O&D bars. So I just want to point out that O&D bars are an important tool that the commission considers in terms of holding individuals accountable. And I think in the last fiscal year, so fiscal year 23, the commission obtained 133 O&D bars, which was the most in the last decade. I only bring this up, you all are probably already familiar with this, but it is something the commission focuses on, and the numbers are on the rise.
No, helpful and scary. The last piece, just with the few minutes that we have, let's talk about settlement. What are the views on how, in particular, cooperation plays, and what is it you have to prove?
Yeah, because we have limited time, I think maybe most helpful for this audience, I'll just go through, I think, the noteworthy settlements where cooperation was noted by the commission. And I actually do think the SEC has done a better job of actually being more detailed about what they think cooperation credit is. If you look at the cases in the past 12 months where cooperation credit was given, the settled AP papers actually have 3 or 4 paragraphs outlining in detail what the company did to get cooperation. And because we have limited time, just focus on the company settlements. So ones to look at are Black & Decker, View Inc., GTT Communications, and most recently in February was this Klupin case. So it's Black & Decker, View, GTT, and Klupin, and those were all cooperation credit public company cases. All of them were accounting violations except for Black & Decker, which is an O&D perk case where they didn't disclose the perks of the directors and the officers. And none of those companies paid corporate penalties. And it was all due to cooperation. And each one of those settled AP orders have, as I said, paragraphs going through the type of things that the companies did. And first and foremost was that each company self-reported, which I think is always going to be important to the SEC. If you haven't self-reported, you're already behind the 8 ball in terms of trying to get cooperation credit from the SEC. Remediation, I think, is key, and you can see that in these AP orders. If you look at the Klupin, that's C-L-O-O-P-E-N case, they talk about how the company not only fired the managers that are involved in the revenue recognition problem at issue, but the company clawed back bonuses. They formed an independent committee to start reassessing how they do the accounting. So there's a lot of remedial efforts that the SEC pointed out. The only other quick thing I would point out in SEC settlements, we talked about sweeps. The SEC has also gone out of its way when they do sweeps. They do these press releases saying, we settled in this sweep 8, 10 companies. There have been some broker-dealer settlements and investment advisor settlements. And they note, like, hey, None of these entities that we did settlements with cooperated, and their penalty was this. But look, and there's always one, there's even a headline in one of them that says, hey, just look at the difference. I think Gubir was quoted saying, just look at the difference. There's one standout because that entity did not cooperate and their penalty was like 6 times larger.
No, and any last words on the SEC front from settlement perspectives?
I would just say, as a resource for you all and for your clients, enforcement manual, which is public, sections 6.1 and 6.2 talk about cooperation. So, and how the SEC assesses cooperation, whether it's an entity or an individual. But that's something we want to talk about. So, I would take a look at that.
And hopefully there will be a pass at one point in time, a complete pass, not just a no penalty pass.
The SEC has done declinations in the past. It's one of those things that it's not publicized as much, though. But
Yeah.
Thank you, Susan. Great job,
Thank
panel.
you.
Thanks for getting us off to such a great start.